Startups begin with a simple promise. The founder says you will work for us and we will pay you. That promise becomes a legal relationship the moment both sides agree on the essential terms: job duties, pay, and duration. In the United States, the relationship is governed by three overlapping layers. Contract law. The written offer letter or employment agreement creates a binding contract, similar to a handshake deal that can be enforced in court. It sets the parties' rights, salary, benefits, and obligations, performance, confidentiality. Agency law. Employees act as agents of the company. Their actions bind the firm to third parties, just as a driver binds a car owner when they drive the vehicle. Statutory framework. Federal statutes such as Fair Labor Standards Act and Title VII and state labor codes add mandatory rules that cannot be waived by contract. For example, even if a startup tries to say you are an at-will employee and can be fired anytime, the law still protects the worker from illegal discrimination or unpaid overtime. Understanding these three pillars helps founders see why a clean written agreement matters, but also why they cannot ignore statutory minimums. The legal foundation is like the concrete base of a building. Contracts shape the design, agency lets the building function, and statutes ensure safety standards are met. The biggest early-stage mistake is treating a gig worker like a full-time employee or the opposite. Common law control test looks at how much control the company has over what, when, and how the worker performs the job. Think of a boss directing a chef's exact menu versus a chef opening his own restaurant. IRS 20-factor test, a checklist covering behavioral control, financial control, and relationship type. For example, does the worker receive a W-2, a benefits package, or a 1099? Economic reality test focuses on whether the worker is economically dependent on the firm like a salaried clerk, or runs an independent business like a freelance designer who has multiple clients. Financial implications are huge. Employees require the employer to withhold payroll taxes, Social Security, Medicare, and to pay unemployment and workers' compensation insurance. For a $100,000 salary, the employer's tax bill can add roughly $7,500 to $9,000. Independent contractors are paid gross. The firm does not pay payroll taxes, but misclassification can trigger penalties of up to 30% of back wages plus interest. Benefits: health 401k match are generally only required for employees, which can add 20 to 30% of salary in cost. Example: a startup hires a software developer on a 1099 for $120,000. The firm saves $9,000 in payroll taxes. But later, a state audit finds the developer was under the firm's daily direction, making him an employee. The state imposes back pay for overtime plus a $35,000 penalty, far more than the tax savings. Hence, using the correct classification test early avoids costly surprises. A solid employment contract is the startup's playbook for the relationship. It typically contains three sections: core terms - job title, duties, salary, bonus formula, and start date. Use plain language. For example, you will work 40 hours per week as a product manager. Covenants - contractual promises that survive employment. Confidentiality, also known as NDA, protects trade secrets. Analogy: a lock on the back door of the garage. Only those with the key, the employee, may open it. Invention assignment means any invention made on company time belongs to the firm. Think of it as a recipe book that the chef signs over to the restaurant. Non-compete restricts the employee from joining a competitor for a set time and geography. Enforceability varies. California bans most non-competes, while Texas enforces them if reasonable. Termination provisions - how the relationship ends. At-will clause means either side may quit anytime, but must give notice, often 2 weeks. Cause versus no cause. Cause, for example fraud, allows immediate termination without severance. No cause may require a severance package, for example 1 month salary per year of service. Garden leave means the employee is paid, but barred from working for competitors during the notice period. Enforcement tip: include an integration clause stating this written agreement supersedes any verbal promises, making it harder for a disgruntled employee to claim extra benefits not in the contract. Startups compete for talent by offering more than cash. Equity is the key. A typical compensation package looks like: base salary modeled using market surveys, for example PayScale and AngelList. For a senior engineer in San Francisco, the 75th percentile might be $180,000. Bonus or commission performance-based, often a percent of salary, for example 10%. Equity grant, usually stock options from a 10 to 15% employee pool. Stock option valuation Black-Scholes. C equals S times N of D1 minus K times E to the minus R times T times N of D2, where D1 equals open bracket natural log of S over K plus open bracket R plus sigma squared over 2 close bracket times T close bracket divided by sigma times square root of T, and D2 equals D1 minus sigma times square root of TS is current stock price, fair market value from 409 evaluation. K is exercise price, usually fair market value on grant date. R is risk-free rate, U.S. Treasury yield, for example 4%. T is time to expiration in years, often 10 years. Sigma is expected volatility, often 50 to 80% for early-stage firms. N is cumulative normal distribution function. Example, a startup grants 10,000 options with fair market value 50 cents, strike price 50 cents, R equals 4%, sigma 70%, T 5 years. Plugging into the formula yields an option value of roughly 25 cents per option, or $2,500 total. Vesting schedule, commonly 4-year vesting with a 1-year cliff. 25% of options vest after 1 year, then monthly or quarterly thereafter. Analogy, unlocking levels in a video game, you must stay in the game long enough to reach the later levels. Liquidity considerations, options only have value when the company is sold or goes public. Therefore, startups often include double trigger acceleration. Vesting accelerates if the employee is fired and a change of control occurs. Explanation, even the smallest startup must obey labor laws. Non-compliance can shut down operations. Wage an hour, FLSA, minimum wage, currently 7.25 federal, higher in many states, and overtime, 1.5 times hourly rate for greater than 40 hours per week. Misclassifying a salaried employee as exempt can trigger back pay claims. Example, a developer works 50 hours per week, but is labeled exempt. The company may owe 10 hours times 1.5 times hourly rate for each week. Anti-discrimination, Title VII, a DA, a DEA, prohibits decisions based on race, gender, disability, age, etc. A simple analogy. A hiring manager must choose the best candidate without looking at the color of the resume. Family and medical leave, FMLA, employees who have worked 12 months and 1,250 hours are entitled to up to 12 weeks unpaid leave for birth, adoption, or serious health condition. Startups often create a paid parental leave policy to stay competitive. OSHA, workplace safety, even a tiny office must keep the workplace free from recognized hazards. For example, ensuring fire extinguishers are accessible and that ergonomic keyboards are provided to reduce repetitive strain injuries. Practical tip, use a compliance checklist each quarter. Verify overtime calculations, update anti-harassment training, and file any required state payroll tax reports. Small, regular checks prevent costly audits. Intellectual property, IP, is the lifeblood of most startups, and protecting it starts on day one. Assignment agreements. Employees sign a document stating that any invention, code, or design created while working or using company resources belongs to the company. Think of it as a gift wrap clause. The creator wraps the idea and hands it to the firm. Confidentiality agreements, NDAs, define what information is secret, such as algorithm or business model, and the duty to keep it secret. Breach can lead to injunctions and damages. Non-compete enforceability varies by state. In California, non-competes are void except for limited circumstances. In New York, they are enforceable if reasonable in time up to 12 months and geography. Startups should tailor clauses to the jurisdiction to avoid waste. Trade secret safeguards. Under the Defend Trade Secrets Act (DTSA) and state UTSA laws, a company can sue for misappropriation. Practical measures include limiting access to code repositories, role-based permissions, password protecting sensitive documents, using clean room development when hiring former competitors. Example, a former engineer leaves for a rival and copies source code. If the startup had a signed assignment and NDA, it can request an emergency injunction to stop the competitor from using the code and seek damages for lost profits. Bottom line, good IP contracts are like a strong fence. They keep the valuable assets inside and tell outsiders where the property line is. Employment disputes are costly, so startups should plan for resolution before a problem escalates. Common claims, wrongful termination, discrimination, unpaid wages, breach of covenants, for example IP theft, and retaliation. A single claim can lead to $100,000 plus in attorney fees and damages. Arbitration clauses. Many startups embed a clause that any dispute will be resolved in binding arbitration instead of court. Advantages: faster, private, and often cheaper. Disadvantages: limited appeal and sometimes higher arbitrator fees. Cost-benefit analysis. Compare the expected cost of litigation, legal fees, discovery, possible jury verdict versus settlement. Formula: expected litigation cost equals probability of loss times potential damages plus legal fees. Example: if there is a 30% chance of losing a $250,000 discrimination suit and attorney fees are $80,000, expected cost equals 0.3 times 250,000 plus 80,000 equals $155,000. If a settlement offer is $70,000, the rational choice is to settle. Risk management tips. 1. Keep thorough documentation, performance reviews, emails. They act like a GPS trail for the auditor. 2. Offer early mediation to resolve disputes before they hit arbitration. 3. Maintain insurance. Employment practices liability insurance, EPLI, to cover large judgments. By treating dispute resolution as a strategic decision rather than a reaction, startups can preserve cash and reputation. Problem 1 - worker classification. Fact: a startup hires a graphic designer for 30 hours per week, pays $30 per hour, provides a laptop, and requires the designer to follow daily project check-ins. The designer signs a 1099 agreement. After 6 months, the designer sues for unpaid overtime. Question: identify the correct classification test and the likely outcome. Answer: apply the common law control test and the IRS 20-factor test. The startup exercises significant behavioral control daily check-ins and provides equipment, indicating employee status. The court would likely reclassify the designer as an employee, order back pay for overtime, and assess penalties. Problem 2 - Black-Scholes valuation. Fact: a startup grants 5,000 stock options with fair market value 40 cents, strike 40 cents, risk-free rate 3%, volatility 80%, and 6-year term. Question: compute the approximate option value per share using Black-Scholes. Answer: plug into the formula. S equals 0.40, K equals 0.40, R equals 0.3, sigma equals 0.80, T equals 6. D1 equals open bracket ln of 1 plus open bracket 0.3 plus 0.64 divided by 2 close bracket times 6 close bracket divided by open bracket 0.8 times square root of 6 close bracket approximately 1.12. D2 equals D1 minus 0.8 times square root of 6 approximately negative 0.78. N of D1 approximately 0.87. N of D2 approximately 0.22. C equals 0.4 times 0.87 minus 0.4 times e to the power of negative 0.03 times 6 times 0.22, approximately 0.348 minus 0.4 times 0.835 times 0.22, approximately 0.348 minus 0.073, approximately $0.275. Option value approximately 28 cents per share, total approximately $1,400. Problem 3 - non-compete enforceability. Fact: a California startup includes a 12-month non-compete that forbids a former engineer from working at any tech firm in the state. Question: is the clause enforceable? Explain. Answer: no. Under California Business and Professions Code Section 16600, non-compete agreements are void except for limited sale of business situations. The clause will be deemed unenforceable, and the engineer can join a competitor. Problem 4 - arbitration versus litigation. Fact: a former employee alleges wrongful termination. The employment contract contains an arbitration clause. The expected litigation cost is $120,000, while the settlement offer is $40,000. Question: what should the startup do? Answer: the startup should invoke the arbitration clause, which will likely reduce costs below the $120,000 litigation estimate. If arbitration costs fees plus arbitrator are projected at $30,000, the rational path is to proceed to arbitration and aim for a settlement around $40,000 if arbitration outcome is uncertain.